Gentleman from Wisconsin, Mr. Sensenbrenner, is recognized for 5 minutes, and would you yield to me for...
I yield to the chairman.
Thank you. In partial answer to Mr. Schumer's prior and Mr. Nadler's questions, I have some quotes from Mr. Schumer, October 5th, 1998, and I quote, "To me, it's clear that the president lied when he testified before the grand jury." October 8th, 1998, Mr. Schumer, "To me, Mr. Speaker, it's clear the president lied when he testified before the grand jury." Then I have Mr. Wexler from September 15th. It's clear from the report that Clinton didn't tell the truth. October 5th, Mr. Wexler, "The president had an affair. He lied about it." So if you want the specifics, whatever it was you relied on,
okay,
I would be willing to cite. Also,
point of personal privilege, Mr. Chairman.
Also, I understand that lurking about is a resolution of censure, and if I'm not misinformed, it says the president made false statements concerning his reprehensible conduct with a subordinate. So, I mean, you must have a sufficiency of specifics to reach those conclusions that you have reached. I guess in law you'd call that an admission against interest. So,
no, could I, point of privilege, since I was...
Simply by way of information. Now, Mr. Schumer has a point of personal
Mr. Chairman,
privilege.
Yes, I do. If my name was...
time.
Well,
would the gentleman recognize me?
Well,
not on his time, with the chair,
I
since...
ask unanimous consent that my time may be told for however long Mr. Schumer wants to...
No objection.
No, wait a minute, that could be pretty long. Go ahead.
No, it won't be that long,
Go ahead,
Mr.
Mr. Schumer.
Yeah, the point is very simple. Yes, I stated that the president lied. I believe he did. First...
When did he lie?
That is, I am not putting forward, Mr. Chairman, in all due respect, articles of impeachment. And furthermore, even if you believe, as many do in this country and on this side of the panel, because we have all, or most of us have stated it, we don't believe it rises to the level of impeachment. To make a considered judgment, whether that is true or not, Mr. Chairman, the members of this House, once we refer something to them, should know the specifics. Second,
may I reclaim my time to give you some of the specifics, sir?
It's not your time anymore. The chairman has yielded to me, and I'd like to finish the point.
We can move along in an orderly fashion,
Thank you,
one at
Mr.
a
Chairman.
time.
Well,
Mr. Schumer, let Mr. Schumer finish. I have a feeling he's nearing the end.
Your feeling in this case, Mr. Chairman, is correct and justified.
That's known as the power of suggestion.
Correct. And very persuasive. In this instance, it is.
That's good, too.
Okay,
I like
my
that.
point, so 3 points. Number one, we're not dealing with fun and games here. If you're putting together articles of impeachment, specifically, you should state which instances you believe not only were lies or mistruths, but which were perjurious. And there is a different standard, and the gentleman knows. All perjury is lies, not all lies, in the common parlance, are perjurious. Second, even if you should assume that they are the same here, we're rising to a level where we're asking to impeach a president. And I find it utterly amazing that instead of giving an answer, these are the 3 cases where he lied before the grand jury that rise to the level of perjury and, more importantly, rise to the level of impeachment. We cannot get the other side to specifically state them. I find that. And instead, you're relying on a statement that I made, which I believe and have believed all along. And that's not a substitute. Again, we're not dealing in verbal jousting here.
Please.
We're not dealing, if I might finish, and I am about to finish,
Mr. Schumer,
winning a
do so.
point. We are dealing with impeaching a president, and if you can't state the specifics and you want to move forward, something is wrong with the process.
I hope by the end of the debate you'll have heard a lot of specifics. And I'm now back to Mr. Sensenbrenner.
Do my 5 minutes start fresh now, Mr. Chairman?
As we speak.
I thank the chair. I would draw attention to the 4 specific instances of false and perjurious testimony that are contained in Article 1. And I know I won't be able to list all of them in 5 minutes, but they fall in 4 basic areas. 1, the nature and details of his relationship with a subordinate government employee. 2, prior perjurious, false, and misleading testimony he gave in a federal civil rights action brought against him. 3, prior misleading statements he allowed his attorney to make to a federal judge in that civil rights action. And 4, his corrupt efforts to influence the testimony of witnesses and to impede the discovery of evidence in that civil rights action. Now, I know I won't be able to get through the instances that we know of in all 4 of these categories, and I would request my colleagues seated to my right to pick up when the red light goes on for me. But I also would like to point out that this is a very clever ruse on the part of the people seated to my left to attempt to limit evidence that can be adduced in the Senate, if it gets that far, to just these instances that I give. And I'm going to say that,
Mr. Chairman,
my time, please.
I just have a unanimous request.
Well, I'll object to whatever it is, because
When
I'd
he's
like to
finished.
finish making my point without interruption, if I could.
You may, and please proceed.
I would just like to point out that the instances that my colleagues and I will be giving should not be construed at any future point in the proceedings as limiting evidence that might be adduced either on the House floor or over in the Senate. But first, relative to point number 1 in the article of impeachment, the nature and details of his relationship with a subordinate government employee. Page 11 of the grand jury testimony. The President testified whether his conduct with Ms. Lewinsky fell within the definition of sexual relations he was given in the case of Jones versus Clinton. He said he didn't believe that. Page 92, when he was asked whether oral sex performed on you was within the definition of you as you understood it, the President replied, as I understood it, it was not, no. The President conceded that the kissing or touching of the breast or genitalia of another person would be covered by the definition of sexual relationships utilized in his definition in the case of Jones versus Clinton. That is at page 95. That testimony is false and misleading in light of the detailed and corroborated and consistent testimony of Monica Lewinsky. Secondly, the article of impeachment says his prior perjurious, false, and misleading testimony he gave in a federal civil rights action brought against him, which is Jones versus Clinton. At pages 457 and 458 of the grand jury testimony, he testified that he believed he had answered the questions truthfully. That is correct, unquote, in the Paula Jones deposition. I think there's ample evidence, including the videotape that we saw yesterday, that that wasn't true. The third point is that the President made prior false and misleading statements that he allowed his attorney to make to a federal judge in a civil rights action. Now, the President's deposition, or excuse me, his grand jury testimony at pages 57 to 61, specifically relates to the affidavit that Monica Lewinsky signed and caused to have filed in the Jones versus Clinton case, where the President said, if it means there are none, that was a completely true statement, unquote. We saw that on the TV yesterday, and that related to the false affidavit in the Monica Lewinsky in the civil rights action that the President's own attorney, Robert Bennett, said that the court should disregard in a letter after more facts came out. Fourth, his corrupt efforts to influence the testimony of witnesses and to impede the discovery of evidence in the federal civil rights action. Take a look at the grand jury testimony, page 43. My time is up. I think that's enough.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
The gentleman's time has expired. The
Chairman.
Chairman, unanimous request.
for a unanimous consent request.
Yes, thank you, Mr. Chairman. I make the unanimous request that Mr. Sessenbrenner be given what time he needs to outline the specifics.
I object.
Well, objection is heard, but we'll get him some more time along the line.
Mr. Chairman.
Mr. Conyers.
Is it unreasonable to ask when we are about to impeach a sitting president that at least in these articles, starting with Article 1, that we articulate which specific statements are perjurious in the text of the resolution? Now, this referring to pages out of Mr. Schipper's presentation and other matters that we've heard here is exactly the problem. This charge of perjury fails because it is vague and does not meet the minimal standards of due process. All the article says before us is that the president lied about the nature and the details of his relationship. What does this mean? And so what I would just like to do is point out to you that in these 4 instances, Clause 1 relating to the nature and the details of the relationship, the president admitted that he had an improper relationship with Ms. Lewinsky before the grand jury. The phrase nature and details of the relationship shows that the Republicans want to impeach the president over what has been referred to as who touched who and where. Now, in the second paragraph, we're talking about relating to an affirming deposition testimony in the Paula Jones case. One cannot impeach the president for reaffirming his Paula Jones testimony. The judge, the Jones attorneys, and the president all agreed that when he was asked about whether he had a sexual relationship in deposition, the definition used there was contorted and confusing. We cannot now bring this to the height of an impeachable position in this article this afternoon. There's also a definite lack of materiality that would throw such an allegation out of any court in the country. The third clause, regarding his grand jury testimony regarding the filing of an affidavit. The president never told Ms. Lewinsky to file a false affidavit, but only that an affidavit may satisfy a legal requirement once she was subpoenaed. That's been reported repetitively here. That is not illegal nor improper, and that is the uncontradicted testimony of both the president and Ms. Lewinsky. The president believed fully that the Lewinsky affidavit was accurate. Lewinsky characterized in her tape conversation with Ms. Tripp the same definition of sexual relations used by the president and consistent with Webster's dictionary. Now, Clause 4, regarding president's testimony at the grand jury to corrupt testimony of Lewinsky in the Jones suit, Monica Lewinsky said that no one asked her to lie. No one promised her a job. We must have heard that nearly 35 times in this committee. This may also be a veiled reference to efforts to find Ms. Lewinsky a job, but the testimony before the committee clearly shows that these efforts started prior to the Jones litigation, and the president never offered her a job. Let me yield just briefly to...
And to answer
Brian
one
Frank.
point that the chairman made, the censure resolution refers to false statements made not under oath in press conferences. The suggestion that the censure resolution is in any way consonant with the perjury is just not true. The censure resolution that the chairman quoted, the Democrat censure resolution, does not at all talk about false statements made under oath, and certainly not before the grand jury.
I repeat, Mr. Chairman, can't we, in reasonableness, on an article of impeachment for perjury, ask that you articulate which specific statements are perjurious? That is all that has been asked here by 4 members on this side of the aisle. Can we do that,
Mr. Chairman?
Yeah, the gentleman's
I would
Chairman.
yield.
The gentleman's time has expired. The gentleman from Virginia, Mr. Goodland.
Thank you, Mr. Chairman. Mr. Chairman, throughout this proceeding, we've been admonished by those on the other side of the aisle to look to the Rodino proceedings for guidance as we proceed, and I think we've done a very good job of that throughout this process. And I have before me the articles of impeachment against President Richard Nixon, particularly Article 1, which was approved by this committee by a vote of 27 to 11 on July 27, 1974. Now, the only member of this committee who remains from the Watergate Committee is the gentleman from Michigan, and he voted for this article of impeachment. The article specifies 9 sections with regard to acts by President Nixon that the committee felt to be impeachable. The first one is making or causing to be made false or misleading statements to lawfully authorized investigative officers and employees of the United States. Does not specify what those statements are, what date, no, I will not yield, what date those statements were made, in what context they were made. It simply specifies that false and misleading statements were made. The second paragraph deals with withholding relevant and material evidence or information from lawfully authorized investigative officers and employees of the United States, and again, that's the entire text of that section. The 8th section says making false or misleading public statements for the purpose of deceiving the people of the United States, and it does not specify what those are either. And I recognize the gentleman from Massachusetts' point that the censure resolution only refers to the public statements with regard to President Clinton. I would only add that that points out exactly how weak the censure resolution is if it doesn't even make reference to the false statements that the President has so clearly made before the grand jury and before the civil deposition. I will in just a moment. The final point I would point out is that the report that was filed with these articles of impeachment by the Rodino Committee with regard to President Nixon and the supporting documentation that was filed does itemize in considerable detail exactly what false and misleading statements were made. So I think we are entirely appropriate. In fact, we have been far more generous than the Rodino Committee was in terms of making information available, in terms of the statements made by Mr. Shippers yesterday and by Mr. Sensenbrenner a few minutes ago. And I would yield to the gentleman from Pennsylvania.
Thank you very much.
I thank the gentleman for yielding. The point has been made that the articles of impeachment then, in Watergate, and now, are based on the record that has been compiled over the course of time. The articles are allegations, final allegations, as part of the article of impeachment that are founded on the massive evidence and records that are part of the record. And the report and the comments of the members of the committee and all the evidence that was presented by counsel are all the foundation. The article simply relies on us who have heard this evidence, who have developed our own opinions on it, to finally record our votes on whether or not the record substantiates the wording of the article of impeachment, then and now.
I yield to the gentleman from North Carolina, briefly.
I thank the gentleman for yielding.
The gentleman from North Carolina, I think, had asked first, and I was yielding to him.
I thank the gentleman for yielding. I think the gentleman has made the exact point that we're trying to make over here, that once you insert the word perjurious, which is a legal term, you are required to specify what phrases, words were
reclaiming my
perjurious.
time. The gentleman has no precedent for that in terms of the
Plenty of precedent for it, Mr. Goodlatte.
Well, there's certainly, well, I've reclaimed my time, I would say, the gentleman, with regard to impeachment articles against previous presidents, including false and misleading statements. There's no distinction to be made here in terms of submitting to the Senate the charge that the president has made false, misleading, and perjurious statements. We simply have a record that we're going to submit to the Senate, and it is in that record, just like it was in the record with regard to President Nixon. I believe my time has expired.
Mr. Chairman, I move to strike the last word, Mr. Chairman.
The gentleman, I guess you haven't trespassed on time yet.
Correct.
The other was a point of order.
Correct.
All right. The gentleman's recognized.
The chairman on his parliamentary acuity.
The gentleman is recognized for a short 5 minutes.
Thank you. I will take a very short 5 minutes, but a pointed 5 minutes. And I would say this, Mr. Chairman. I am just utterly amazed at where we are here. We are seeking to remove the President of the United States. By general concession, this first article is the strongest case that the majority has, that the authors of the resolution has, because it deals with perjury before the grand jury. And we cannot get from anyone thus far a list of what specific perjurious statements have been made.
Will the gentleman yield?
That is,
Will the gentleman yield?
if the gentleman would make my short 5 minutes a long 5 minutes, I certainly will yield.
I will. I just want to say that the information has been handed to Mr. Nadler, a transcript of the remarks of Mr. Shippers yesterday, which contain extensively the information you're seeking.
Gentleman, yield.
He's
reclaiming my time, Mr. Chairman. Are we then saying that the entire portion of Mr. Shippers' testimony yesterday, or presentation yesterday, all of that could be attached to the articles of impeachment as representing every one of those is what the author of the resolution believes to be perjurious, point A, and B, nothing more? And I yield to the gentleman. If the gentleman believes that, then our question is satisfied. At least there is a list of particulars. And I would remind the gentleman, and particularly my good friend from Virginia, that Watergate, there was no perjury charge, that it is a fact of common law that when you are indicted for perjury, the actual perjury words be included in the indictment, and that if you're asking for precedent, which the gentleman from Virginia was, I only look to Mr. Starr's indictment of Webb Hubbell for perjury, which had specific items of perjury. I yield to the gentleman.
This is not an indictment. This is not a criminal proceeding. You keep casting it as such. It isn't. This is impeachment, as we're reminded ceaselessly by everybody else.
Reclaiming my time, I would make a couple of points. Yes, the gentleman is exactly correct. This is not a specifically legal proceeding. But the entire basis of what the author and the majority have called for here is the fact that the President broke the law, that Americans can never trust the President again if we allow perjurious testimony to go forward. And I think at the very least, in other words, you're making a case based on the law. That's been the entire case that I've heard the majority make. And now all of a sudden, we're getting into the sort of never-never land of page 7 of the articles, when the President makes a misleading statement or a false statement, whether it's perjurious or not, that might be grounds for impeachment. And I find this a sad day if that is the case. And so what I would ask, again, I would renew my request, because I think it's important enough and serious enough that we take that into account, that in one way or another, I'd even, and I'm only speaking for myself, be willing to take a short recess so the majority could prepare it, that we get specific words that are alleged to be perjurious. As I read Mr. Shippers' presentation, and I imagine it's some 15 or 16 pages based on Article 1, based on the grand jury testimony, there are all sorts of charges and allegations. Some are done in paragraph form, some are done with specific quotes. There's not one sort of set pattern. I think what is required of us here today, because we are seeking to impeach a president, and many of us argue that that is a step that even goes beyond the criminal law, because not every, at least in my judgment and in the judgments of many scholars, not every violation of criminal law rises to the level of impeachment, but at least it ought to be with criminal law, that we have the specific words listed. So I would ask, in all due respect, given my, and I'm about to conclude, my respect for the chairman, that we be given that specific list so that we, the full House, and if it should come to it, the Senate will know exactly what we're talking about here.
The gentleman from Georgia, Mr. Barr.
Thank you, Mr. Chairman. Mr. Chairman, although you are absolutely correct that this is not a criminal proceeding in the strict sense of the word, I think there are some parallels that can be drawn and some lessons that can be gleaned from looking to and referencing procedures in the Federal Criminal Code. The nature of what we're doing here is similar to the drafting up of an indictment, not precisely, but similar to. Yet the criminal rules themselves provide for what is called a bill of particulars. Were an indictment, which is what the other side is alleging we are basically doing here, deemed to have to include every single element of every single allegation that will support the criminal charges alleged against the defendant, then there would be no need in the criminal rules for a bill of particulars. The criminal rules, particularly Rule 7, does indeed provide general guidance on what is contained and what must be contained in an indictment, which is a charge that puts the defendant on notice as to the nature of the charges against him or her. Subsection F of that same rule provides for what I refer to a bill of particulars. A bill of particulars is something that defense attorneys almost always seek. They seek that because they are seeking additional detail with which to prepare their defense. The appropriate time to file a bill of particulars is after the indictment, in order to test the sufficiency of the indictment itself. Were a bill of particulars, which is what the other side is cleverly asking for at this preliminary stage, to be required, then every single indictment ever issued by a federal grand jury would be voluminous and would, in fact, limit the prosecutors in advance of preparing their trial, responding to motions, or preparing evidence, only those specifics alleged completely as to every single element of proof. The fact that our federal rules of criminal procedure provide for, in this instance, a two-step procedure is instructive here. You allege the general parameters with sufficient clarity and detail only to put the defendant on notice so he or she can begin preparing their defense in the indictment. What comes after the indictment, which in this case analogous to what we would be doing after this leaves the House, if it does leave the House, would be a whole range of procedures during which time the sufficiency of that charging instrument is tested and during which time the evidence itself is brought forward, debated, in this case in the Senate, in a criminal proceeding, in the courtroom. Now, what the other side is doing is, of course, very clever, but very disingenuous. What they are seeking, as a gentleman from Wisconsin noted a few moments ago, they are seeking not to do what they appear to be doing, and that is to provide sufficient data, sufficient information for the president to know what he is charged with. He knows darn well what he's charged with. There will be, as part of the record that goes to the Senate, tens of thousands of pages of evidence, hours of testimony here, hours of debate here. That will all be the record that will go there. What they are seeking to do is to limit in advance what the Senate can do. They are trying to tie the hands of the Senate. That is improper. That was not done in any prior impeachment proceedings. It is not done in criminal proceedings. They are simply trying to maneuver their way, anticipating that this does go to the Senate, to limit arbitrarily the data and the evidence and therefore the charges on which the president can be tried. We have in this indictment, in this document that we have here, we have alleged with sufficient particularity to put the president on notice, any reasonable person on notice, with the nature of the charges against him,
the gentleman's
so he can defend against them.
The gentleman's time has expired. The gentleman from California, Mr. Berman.
Thank you, Mr. Chairman. I'd like to make
We're interrupting the proceedings just for a moment because Joe Lockhart is speaking at the White House. He is the spokesperson who earlier today told us that President Clinton would not be speaking about this issue at 11:30 Eastern Time this morning, and he did not. Let's listen in now.
I'm not going to get into the internal deliberations of the president's staff.
Think?
No, he's been tied up most of the morning with the presidents from Central America. He did a meeting beforehand. You saw him in the Rose Garden. I think he spent some time with the ambassadors afterwards. Okay, but he's had a busy morning.
Earlier today, it was clear that he was weighing. We were told that he was weighing whether he wanted to say something on the impeachment. Is he still weighing it, as far as you know?
I don't think he stopped weighing it.
Is the President aware that both Republicans and Democrats on the House Judiciary Committee have today called upon the President to say something more?
No, of course he is. It's in all the newspapers.
And what's his reaction to that?
I didn't get a specific reation to that from him.
The idea that he has made a decision.
I am not leading. I would lead you away from that specifically and without any spin.
Any options?
Yes.
But isn't it a concern that the longer he waits, for example, if he came back...
Why don't we stop here? I'm just not, it's not productive. I think I told you this morning about what the state of play was, and I'm just not going to get into mindless speculation about what might or might not be going into any such decision.
Have you watched any of the proceedings today?
Not today, I don't think.
What's he doing for the rest of the afternoon? Is he consulting with aides about this? Is he talking to his lawyers?
On this subject, I think he spent a few moments talking with some of his aides this morning. He's been, as I said, pretty busy on some other subjects through the morning. Is he making a call? Okay. Okay. He's got a meeting later this afternoon, which should be, I think, a combination.
Well, the answer we were waiting for came. The president is still mulling over all of this. Last night he said, let me sleep on it. Today he is apparently waking on it. And according to Joe Lockhart, the secretary or the spokesperson there, he has not yet made a decision on whether he will offer yet another apology or at least a speech on this issue in the days to come. I can tell you this, the president leaves tomorrow, 6 a.m., for Israel and Gaza, returns next week, still has the possibility of making a speech on Wednesday before the full House makes a vote on all of this. In the meantime, clearly, there is talking still going on Capitol Hill, so let's listen, why don't we?
The allegation of perjury or make the notice and specification of reasons. I yield to my colleague from Massachusetts.
As a matter of fact, Kenneth Starr does meet the specificity requirements, not in the criminal indictment, but in the referral. If you look at pages 148 and 149 of the referral, Kenneth Starr very crisply lists 3 counts of grand jury perjury and is specific. The problem the majority has is that they are too trivial. The majority does not like what Kenneth Starr came up with. So what we have here is an obfuscation. Kenneth Starr says, he said 1996 February, he should have said November 95. Kenneth Starr says he said he believed himself when he testified in August. He said he believed himself when he testified in January. And Kenneth Starr says he touched her, and he didn't say he touched her, and she said he touched her. The problem is that Kenneth Starr does do what the majority doesn't do. Kenneth Starr gives 3 specifics of grand jury misstatement. The majority, I will give them credit. They know a losing case when they see one. They look at Kenneth Starr's 3 cases and they say, wow, we can't defend those. So they obfuscate and dress up. Yeah, I'll give the gentleman's time. He can have it back.
I just want, Kenneth Starr alleged 3 specifications of false statements.
Right, he said lied under oath. He didn't call it perjury. No, that's true. That is true, and I guess the majority has finally made it clear. They will not tolerate Kenneth Starr's softness on the president, and they're going to toughen it up. But the fact is that they do it in a very, very inaccurate and inadequate way.
Would the gentleman yield, just for one question?
The gentleman's time has expired. The gentleman from Florida, Mr. McCullum.
Thank you, Mr. Chairman.
I think what we're dealing with today is a debate on a smokescreen, and I really believe that, as some of my colleagues have said on this side a moment ago, that what we have before us is 60,000 pages of documents, and we had a very excellent summary of the specific details of where the president committed perjury before the grand jury from Mr. Shippers yesterday. But I'm going to discuss, rather than getting into the prolonged technical discussion about whether we should be more specific or not, I'm going to get into some of the specifics of why I believe that Article 1 should indeed be an impeachment of the President of the United States. The President clearly, to me, committed perjury before the grand jury when he testified with regard to whether or not he engaged in sexual relations with Monica Lewinsky with respect to the definition given to him by the judge in the court. You remember that was a very specific definition, and it included in it touching of breast and genitalia. And on page 547 of the big document we've got published here, this is part 1 from the office of Kenneth Starr, is part of the testimony, and the entire transcript is here of the president's deposition before the grand jury. And on page 547, he's been asked about the particulars of that statement and that definition. And he's been asked questions that says, if the person being deposed touched the blank of another person, would that be, and with the intent to arouse sexual desire, arouse or gratify as defined in definition 1, would that be understanding, under your understanding then and now? Answer, yes, sir. Sexual relations? Answer, yes, sir. Question, yes, it would? Answer, yes, it would. If you had a direct contact with any of these places in the body, if you had direct contact with the intent to arouse or gratify, that would fall within the definition. That's the president's answer. So then the question goes on. So you didn't do any of those things? Answer, you? Question, with Monica Lewinsky? Answer, you are free to infer that my testimony is that I did not have sexual relations as I understood this term to be defined. Question, including touching her breast, kissing her breast, or touching her genitalia. Answer, that's correct. That's specifically, if anybody wants to know, where the president committed perjury. Now, why do I conclude he did in this particular set of circumstances, if we want to be specific? It's because Monica Lewinsky testified that on numerous occasions he did touch those particular parts of her body. And that he, in fact, that her testimony about that was corroborated and is corroborated by a number of specific witnesses whose testimony we have in the record that Mr. Shippers referred to yesterday. Contemporaneous discussions that she had with them about this over a period of time. I can cite you to the testimony of Catherine Alday Davis, Nasa Erbland, Natalie Rose Ungavari, Andrew Blyer, and Catherine Estep. Who, by the way, was a counselor for her, a psychiatrist, I suppose, or a counselor of some sort. At any rate, this was contemporaneous. It's believable. It's consistent with her testimony she gave herself before the grand jury. She's believable. The president is not. Anybody who reads this can't help but come to those conclusions. And that's taking the president's own admissions into account. Now, with regard to other features of this, the president also testified in the grand jury in this document on page 571 with regard to the affidavit that was in question, and I hope she'd be able to get out of testifying on an affidavit. Absolutely. Did I want her to execute a false affidavit? No, I did not. He lied in that case. He committed perjury in that case because, of course, he wanted her, with all the evidence we have before us, to execute a false affidavit. We've been over that, about the circumstances of their original meeting, about all the details that you could imagine about those circumstances. He clearly anticipated that she would, consistent with her cover stories they prepared before she went to give her testimony in the Jones case, file a false affidavit. Mr. Shipper was over that time and again yesterday. And that is another question that goes to the fourth basis in this, and we could go on and enumerate a lot of them. The fourth basis of our particulars in the Article 4 that we're here today deals with the question of his corrupt efforts to influence the testimony of witnesses to impede the discovery of evidence in that civil rights action. And we could go on and on and on with the list, and I'm sure we will today. But I'm convinced, beyond a reasonable doubt, not just clear and convincing, that Article 1 is more than justified as an article of impeachment.
The gentleman's time has expired. The gentlelady from...
Mr. Chairman, I move to strike the last word.
Ms. Waters, I've just been reminded by Mr. Nadler that he was next, and I'm sorry.
No problem.
Mr. Nadler.
Thank you. I move to strike the last word. And, Mr. Chairman,
5 minutes.
Mr. Chairman, I wish to yield to you to answer a question. As the author of this proposed article of impeachment, do you intend that these alleged perjuries to be Mr. Starr's three perjuries on three allegations on pages 148 and 149 of the report, or do you intend to go beyond that and have some other perjuries beyond these three he mentions?
If the gentleman would yield, I would believe that there are
I didn't
more.
ask you. I asked the sponsor of the author of the resolution.
You're asking Mr. Hyde this question,
Yes,
not
I
me.
am. He's the author.
I really don't know. I think the three.
Thank you very much, reclaiming my time. Reclaiming my time, Mr. Chairman.
Oh, you don't want a full answer.
You said you didn't know. That's the answer.
Well, I said I'll try to.
Oh, I'm sorry.
Be more precise if you
I'm sorry.
give me some
Go ahead.
time.
Go ahead.
Yeah. Okay, go ahead. Finish your time.
No. You said I thought you'd finished.
I finished what I wanted to say. I will try to get more information. My present opinion is we will stay with what Starr has and what Mr. Shippers has.
Starr and Shippers.
Oh,
Thank
yeah,
you,
Starr and Shippers.
Thank you, Mr.
Would the gentleman yield?
Yes, quickly.
Starr has three allegations of perjury under the grand jury. The date they met Lewinsky, whether there was a touching, a lying, a false statement. Sorry, excuse me, that's well corrected. And third, whether oral sex was committed. Shippers lists a whole bunch of other things. Which are we referring in this article? I would yield to the chairman to answer. To those three in the Starr report or to others that are listed in the Shippers report as well?
Yeah, we're referring to everything in the Starr report.
Thank you. Reclaim just the Starr report?
The Starr report.
Starr report and the Shippers report.
All right. Thank you. Reclaiming my time. Starr and Shippers. So you're going beyond Starr to other unspecified statements. Mr. Chairman, let me say the following. We keep hearing from the other side of the aisle in this committee that the whole reason for this proceeding is that we must defend the rule of law. Well, the rule of law demands and establishes due process. And the fundamental of due process is that a defendant is entitled to notice of the charges against him. Perjury, the central allegation here, demands specifics. The law says the specifics must be listed in the indictment. I would be satisfied with a contemporaneous report, a contemporaneous list now, not in the language, but a contemporaneous list now, precisely as Mr. Sensenbrenner says, so that the Senate is limited, so that the House is limited to the charges we make, so that the defendant has notice of what he must defend against. That is the essence of due process. Now we are told by the gentleman from Virginia that the Nixon allegation in the article, which wasn't the central article as this one is, didn't list the specific language, but the fact is the report did. What we're saying today is that you can have no due process, you can have no fair notice of the charges, if the charges are subject to expansion later, if the charges are anything that can be derived from a 100-page Shippers report full of loose allegations unspecified, and the fact of the matter is this whole subject is revealed for the farce it is if the majority cannot answer the question and say, what are the specifics? I didn't demand that the specific language be in the article. I asked what any defendant is entitled to, even the President of the United States, that we have notice before we vote on these, so that we can debate them intelligently, so that on the floor of the House members know what they're voting on, and so should they go to the Senate, the President knows what he's dealing with. And the law requires, unlike what Mr. Barr said, when you deal with perjury, the law requires the specifics in the indictment.
Will the gentleman yield even though his time is up?
I will yield.
Yeah. If my good friend would listen to when we talk over here, I know that's a major effort, but if you would, you will hear the answers to your questions. Already, many of the answers have been provided, and more are on the way.
Reclaiming my time for 2 sentences, Mr. Chairman, the problem is that all the discussion is not satisfactory for one reason. What we need, what is required, is a specific list of the words, a limited list of the words not subject to expansion later, specific notice of the allegation.
Well,
that's all we ask.
If you will
so that
listen,
the House can know what it's debating.
if
and
you
what
will
it's not
listen
debating.
carefully, you will get your answer. The gentleman from Arkansas, Mr. Hutchinson.
I thank the chair. And let me just review where we are here for a moment. I believe it was yesterday and the day before we heard the President's Counsel, the Minority Counsel, respond very specifically to the allegations of perjury that were contained, that were alleged for the grand jury, which is a substance of Article 1. The President's lawyer and the Minority Counsel did not have any problem in responding very specifically because they knew the specifics as to the allegations. They were set forth in the Starr report. They were set forth in the Shippers report. But I think that whenever you look at the drafting of this particular article, it is consistent with the previous articles of impeachment that have been drafted for perjury in previous cases before this House. You can set forth specifically in the articles the question and answer, but in this case we gave due notice because of the different areas that are being alleged to be perjurious in the articles of impeachment. So there's adequate notice there, and Mr. Barr from Georgia is correct that if it goes to the Senate and more specificity is desired than under a bill of particulars, that can be provided. But this would be sufficient under any indictment that would be presented in a criminal case. But this is not a criminal case. This is an impeachment proceeding before the House of Representatives, and perhaps it will go further. But these articles give the adequate notice, and whenever the statement perjurious is in there, that means it is in the nature of perjury. It's in the nature of false statements. We're not going on technical legal definitions, technical criminal statutes. This is a proceeding protecting the public trust of the United States. But my friend from New York has asked for specific question and answers in the grand jury testimony. And so let's look for a moment. In the articles of impeachment, the first reference is that there was perjurious statements given concerning the nature and details of the President's relationship with a subordinate government employee. I'm referring to the actual grand jury transcript that's not bound in the Starr report, but it's the actual transcript. And on page 6, the President refers to the affidavit that he submits, and or the statement that he gives to the grand jury. And he says that his relationship with Ms. Lewinsky did not consist of sexual intercourse. They did not constitute sexual relations, as I understood that term to be defined.
Well, on that note, we do need to take a break. I'm Shepard Smith in Fox News headquarters, and our coverage continues in just a moment. Please stay with us.
President of the United States in the...
It's a beautiful morning.
Bounce gives clothes, linens, and towels a freshness you can't help but notice.
And just smile.
In fact, you might find that adding a little bounce to your morning puts a little bounce in your step. And because Bounce has time-released freshness, you can count on fresh days day after day. So put a little bounce in your morning and have
a beautiful morning.
50,000 people are signing up for cell phone service today. You know what else? 148 million people are hooked up to the net. 7 billion emails are being sent. What's it all mean? There's a communications revolution going on, and one company is right in the middle of it all. Lucent Technologies. We make the things that make communications work.
Hi, we're in Miami. We've got a sink, new Perk Plus with clean conditioning. We're washing hair and we're changing minds. Excuse me. Hi. Excuse me, ma'am. I ask you a couple of questions. Hi, can I ask you a couple of questions about shampoo? Shampoo? Have you ever used one of those shampoo and conditioners in one? Have you ever used one of those shampoo and conditioners in one?
No. No? Yes.
What'd you think of it?
Didn't like it. I hated them. Kind of limp and dead. Weighs your hair down.
We're 0 for 4, my friend. Look at this. I don't know what you've heard about PERT Plus in the past, but it's totally changed. And I've got a sink right over there, and I got a sink right over there. It's reformulated PERT Plus. Here we go, ladies. All right, but this stuff, since they redid it, it's been revolutionarily redesigned and has water-based conditioning. You see, there's no buildup, so your hair's going to feel clean. Tell me what it feels like.
Wow. It's wonderful light. It feels light. It's light and it does seem lighter.
Oh, wow, that's great. Hey, new PERT Plus with clean conditioning. Fantastic. We're washing hair and we're changing minds. Excuse me.
The president's men and women have spoken. Now decision time. If it does come down to a full House vote, is the deck stacked against the president? And even if he's impeached, what are the odds of conviction? Get the latest buzz this weekend with the Beltway Boys. 'Cause in Washington, there's never a dull moment. As the impeachment debate continues, the fate of a president remains in question. As both sides rest their case, will the House vote to impeach? Stay with Fox News Channel for continuing coverage of the impeachment debate.
Before this committee. It is
and welcome back. As the argument continues in Washington, the Democrats asking for specifics of perjurious charges here. I'm joined in Washington by Democratic consultant Jeff Brown, and here in our New York studios by GOP strategist Dylan Glenn. And Dylan, let's begin with you. They say they're asking for specifics. What are they wanting?
Shep, that's a great question. I don't think they know what they want. I mean, I think this is more of the same, a ruse to try to change the subject, to try to delay, and it's a shame. I think the Democrats have really behaved irresponsibly with respect to these proceedings because, you know, what's perjurious has been outlined by Mr. Shippers in more than adequate fashion, and they have the vast volumes of documentation in front of them. This is an attempt to change the subject.
Jeff Brown?
Oh, I think that the Democrats absolutely have a right to know exactly what is perjurious. The problem you have with perjury is it's a very technical issue, and you have to be very specific about what was said because there are many defenses to it. And they have a right to offer that so the president can offer an adequate defense on the House floor.
Let's listen back in now as the debate and argument continues on Capitol Hill.
The framers of the Bill of Rights included in the Fifth Amendment a guarantee of grand juries for federal court in order to protect ordinary citizens against the power of federal prosecuting authorities. And even the Supreme Court in U.S. v. Williams states that the whole theory and foundation is that it belongs to no branch of institutional government, serving as a kind of buffer between government and the people, and, quote, it swears in its own witnesses. Mr. Chairman, there's a case Pryor v. United States, a 1977 case, where the question was whether or not a perjury charge could lie when the defendant said that the court reporter swore the person in, and the foreman of the grand jury said that he had actually sworn him in. And I'm going to read part of that case. The defendant claims that the government failed to prove that he was duly administered an oath by the foreman at the commencement of his testimony. He relies upon the certificate of the court reporter, a pre-printed form, describing the proceedings as a deposition. He argues that this certificate conclusively establishes that the court reporter, rather than the foreman, administered the oath to him, and that the notary public, not being authorized to administer the oath to grand jury witnesses, the case must fail. While the certificate might be sufficient, if not contradicted, to overcome the presumption, the court goes on to say that the foreman of the grand jury actually testified that he, in fact, had given the oath. It is for the jury to weigh the relative credibility of the foreman and the form. There was ample evidence from which they could and did conclude that the oath had been properly administered by the foreman. Mr. Chairman, that would be totally irrelevant if we accept Mr. Starr's statement that it didn't matter who gave the form. Now, all of this intrigue is interesting, Mr. Chairman, because Mr. Starr now tells us that there's an official transcript. The one he sent us just said that William Jefferson Clinton being duly sworn, whereas with Monica Lewinsky, he said the grand jury, in her grand jury testimony, it said Monica Lewinsky being duly sworn by the foreperson of the grand jury. I don't know why we got a different form. This is an important issue before us, and if we're going to, I'd like to know from Mr. Starr why this was kind of obfuscated with Mr. Clinton and why we were not told this other information, because he had told us in his testimony that there's no question, well, he said that a jury would convict and all of the elements of perjury were there. Mr. Chairman, I don't know why we got a different transcript in our form than he's referring to now, but this is an issue, and I think goes to the credibility of the witness. I'll yield to the gentleman from Massachusetts if you had a comment. Okay. I'll yield back, Mr. Chairman.
I thank the gentleman, Mr. Coble, gentleman from North Carolina.
Mr. Chairman, I yield my time to the gentleman from the Roanoke Valley of Virginia, Mr. Goodlatte.
I thank the gentleman for yielding. Mr. Chairman, first, in response to the gentleman from Virginia, I'd direct his attention to Title V of the United States Code, Section 2903, Oath, Authority to Administer, subsection B2, an individual authorized by local law to administer oaths in the state, district, or territory or possession of the United States where the oath is administered. And then, of course, you turn to the District of Columbia law, which authorizes the notary public to administer the oath. I think that
in a grand jury proceeding?
Let me go on to the other point that I want to make here first, and that is with regard to this issue of perjury. I think the gentleman from Georgia and the gentleman from Arkansas have been absolutely correct in terms of the nature of this proceeding being different from a criminal proceeding. But in a criminal proceeding, there are two types of perjury. One, where you have two different statements made by an individual, and the issue is which one is the correct statement. You do list those with specificity. If you're viewing that as this type of case, the report that will be submitted with this will list those things or incorporate other things such as Mr. Schipper's.
As this appears to be an argument which will not die quickly, we've decided to take a very brief commercial break. Stay with us.
Knows what we're referring to because he addressed.
Let us celebrate this supper with merriment, with song, with crescent rolls.
Did someone forget the crescent rolls?
Don't worry, they're right here.
Warm, flaky Pillsbury crescent rolls are one Christmas tradition you don't want to forget.
Let's eat.
Nobody loves cars more than I do. Each one is a work of art. So when the maker of all these chose a new antifreeze, it got my attention.
General Motors now uses the deck school technology of Haviland Extended Life Antifreeze in virtually all its new vehicles. The same patented formula you can use in your car for 5 years or 150,000 miles. So do what GM did. Switch to Haviland.
I use it in my car. I only wish this were it.
Around here, you can't buy a reputation for quality. You have to earn it, the way Wall did. Wall invented the first electric clipper 80 years ago, right here in America's heartland. And they're still the choice of millions of professionals worldwide. Today, you can get that same quality and reliability at home with Wall clippers, trimmers, and shavers, all backed by the Wall family commitment to innovation and value. That's what being a leader is all about. Wall, bringing professional quality home.
Every day I wake up and pour myself a cup of that rich Folgers aroma. The best part of waking up, it's the do-up in all I do. The mountain-grown aroma always coming through. Oh, the best part of waking up is Folgers in your cup. The best part of waking up is Folgers in your cup.
Hungry Jack biscuits now have the delicious taste of cinnamon and sugar in every flaky layer. These are really good.
Hungry Jack cinnamon and sugar biscuits.